FBI Deputy Director Andrew McCabe is off the job, effective immediately. While some reports say his departure was a mutual decision, others are claiming he was removed from his post. In recent weeks, as you know, McCabe has been a favorite target of Donald Trump's, a status probably not helped by the recent Washington Post report that Trump asked McCabe who he voted for back when he was acting FBI director. This is just the latest wrinkle in a series of twists and turns, raising questions about the president's contentious relationship with his investigative and intelligence agencies. And it comes as some lawmakers are weighing whether they might have to take things into their own hands to protect special counsel Bob Mueller. Joining me are Nancy Gertner, former federal judge at the U.S. District Court in Boston, appointed by President Clinton. Judge, it's good to see you. She's now a professor at Harvard, by the way. I forgot that part, but I got it in there. And attorney Michael Sullivan, who was appointed by President George W. Bush. He was the U.S. attorney here. He's now a partner at Ashcroft Law. Good to see you, Michael. Thanks so much. Does the departure of McCabe have any significance in the Mueller investigation, or to paraphrase Freud, is a resignation sometimes just a resignation?
It depends is the answer. I wish I could say. I mean, if this were, if this was sort of direct pressure from the president.
Well, there has been direct pressure from the president, even if it didn't lead to the actual departure.
I mean, the question is, where does this fit in terms of a pattern? Is there a pattern in which you get rid of Comey, you get rid of, you try to get rid of Mueller, as last week's story was, and now you're trying to pressure somebody else who's involved in the Russian investigation. The question is, does it fit part of a pattern? Standing alone, there may be an explanation for it, but is it part of a pattern as to which, that raises issues of obstruction of justice?
Does it matter, or is it just another departure?
It's another departure, and I think it's coincidental. The fact of the matter is every director of every law enforcement agency within the federal government has a right to put in their leadership team. It's not unusual that the deputy director is told that your time is up as the deputy director, and these are your options.
George Bush asked you how you voted in the presidential election?
I don't know if he needed to. But
That's right. It was perfectly clear.
So can we move to the tougher case, or maybe more important case? Robert Mueller, as you mentioned, obviously the New York Times did a piece that's confirmed by virtually everybody, even though the president denies, says it's fake news. Does this help Bob Mueller? Does the desire to fire Mueller, which was only recanted apparently because the White House counsel said, I'm quitting if you fire him, and so the president stepped back. Does that help Bob Mueller build an obstruction of justice case, Michael?
No, that in and of itself, absolutely not. I mean, the fact of the matter is, I think the president's frustrations was the hiring of Bob Mueller under the circumstances in which he was hired. The Department of Justice had ample resources to conduct its own investigation, notwithstanding the fact that the Attorney General had recused himself. I think the president's frustration was that the department moved too quickly to bring in a special counsel. And I don't blame him for that.
A department that was in his administration, though. It isn't like the enemy made the appointment.
It's special counsel, not independent counsel. The Deputy Attorney General has not recused himself from the investigation. Technically, Bob Mueller reports to the Deputy Attorney General, not the Attorney General. The fact of the matter is the Department of Justice operates independent of the White House.
Theoretically.
Well, in practice, when I was there, it did, and I think it does today.
So does the Mueller thing matter? Michael thinks not.
It matters because this is the first time that it's clear that you're trying to get rid of someone because of the Russian investigation. There may have been some equivocation about...
Well, it was clear in Comey. He said to Lester Holt on NBC.
He said it earlier. He said it was because of the Hillary stuff, and so there may have been some other alternative explanation. But this time it was absolutely clear Mueller was doing the investigation of Russia. The other thing that's very interesting is that when we talk about obstruction of justice, people focus on the president. If there is an obstruction of justice case, it may also pertain to those around the president, which may be why he has the leakiest administration ever.
I want to stay on Trump, though, for a second and play some sound from a prior president who you'll probably remember this moment. Here's Bill Clinton on January 26th of 98. Here he is.
I did not have sexual relations with that woman, Miss Lewinsky.
Now, Michael, the reason I played that was not for salacious reasons, but Ken Starr said, a special counsel in days gone by, said it was the lying of Bill Clinton that helped delay the investigation to begin with, which, according to Starr, bolstered the obstruction of justice case. Well, if Donald Trump and his staff are lying in the same fashion about the desire to fire Mueller, and virtually every media outlet has confirmed, including Fox News, by the way, and we'll talk about that later, that it happened. How is this any different from what Ken Starr said about Bill Clinton?
Well, I'm not sure I would necessarily agree with Ken Starr saying that that was kind of the prelude to the obstruction of justice, because President Clinton lied about, whether or not he had a sexual relationship with Ms. Lewinsky. The fact that the president...
But he did say it, whether you agree with him or not. That is
what
Starr said.
Well, he did say it,
yeah.
But the fact that the president, in his mind, thinks that Bob Mueller should be fired should not be evidence of an obstruction of justice.
Well, that's not the issue. If he lied, the issue in this case,
when you say lied,
he said it's fake news. He said it never happened. Huckabee Sanders is saying his spokesperson said it never happened. Do you buy the Starr? I'm sure you were not a big fan of Ken Starr's at the time, but do you buy the Starr connection thing here or no?
I mean, if what he was saying here is that when the president began to lie about this affair, he began to look more closely at what else the president was doing with respect to obstruction of justice. In other words, it opened up a wider avenue to investigation. That makes perfect sense here. I mean, there are lots of this. A moment ago, Mike said that the resignation of McCabe standing alone. We're not talking any longer about standing alone. We're talking about a pattern of conduct that began at the end of January and now of 2017 and now continues. It's really
but you said yourself you don't know if it stands alone. You don't know. He doesn't know if it stands alone either, but nor do you.
Nothing standing alone is obstruction of justice unless he is saying explicitly, I want to get rid of Mueller because he's getting too close to my people in the Russian investigation. But one rarely finds direct evidence like that. It will be a pattern of conduct beginning with the firing of Comey and the circumstances surrounding that up until now.
Can we, you're going to say something or no?
I was going to say there could be perfectly legitimate reasons for the president's sentiments on wanting to fire Bob Mueller, starting with questioning, why do we hire him in the first instance? Why can't the Department of Justice conduct this investigation? I'll have more confidence with the Department of Justice conducting the investigation versus somebody from outside.
The whole issue here is intent, is it not? No one questions
right.
the fact that he can do this.
Right.
The question is there corrupt intent on the part of the president?
Right, which is why pattern is important,
Understood.
Which is why inconsistent versions of the same event are important. Those are the kinds of issues.
Can we move from Washington, D.C. to a Michigan courtroom where there was a Judge Aquilina, who most of us had never heard of, who became a celebrity, if not more, after her sentence, the trial and sentencing of Larry Nassar, the Olympics doctor. Let me first play for you something she said to the victims. And as people know out there, 150, 160 women and teenage girls testified during the sentencing phase of this. Here is the judge.
You have a sterling voice of truth. You are a sterling tower of strength that will not be pulled down. You're a lightning rod along with your sister survivors.
Now, to be clear, this is not during the guilt or innocence phase.
Right.
We rarely hear this kind of thing. Did she cross the line here, Judge?
I don't think so. I think that saying to the victims, you're talking about someone who's already pled guilty, and saying to the victims that your strong is not really. I don't think that she's crossing the line particularly.
Doesn't show a bias that vis-a-vis the sentencing?
When you're dealing with someone who has pled guilty to these number of charges, even the charges for which he was tried, let alone the numbers of victims. You're not. The bias is towards someone who's pled guilty. I don't think that that's a particular problem in this case.
How about you? Do you?
No,
he would never think so.
I think the victims have an absolute right to be heard in the sentencing phase of the proceedings.
Well, I don't think anybody's quarreling with that. I think it's the characterization. I mean, what I'm broaching
Right.
is the characterization of the judge. It was almost like she was their lawyer, at least from the outside.
Right.
I think while we were all cheering her on, to be perfectly candid, at the same point, when you reflect upon... Let me play something else that I think is far closer to the line. I'm the weakest lawyer in this group, but nevertheless, I am a lawyer. Here she is talking to the defendant himself. Listen to this.
Our Constitution does not allow for cruel and unusual punishment. If it did, I have to say, I would allow someone, or many people, to do to him what he did to others.
I spent much less time in a courtroom than you two. I've never heard a judge say anything like that to a convicted defendant. Have you, and does it trouble you?
I don't recall ever hearing a judge say something like that to a convicted defendant.
She's basically, if you get raped in prison, be it.
It is troubling.
It's very troubling. No, I agree. I agree.
Is that troubling to the point of what?
Are you pushing me over the line? Yes, that's over the line.
And so what do you do with that?
There's nothing one can do with that because he's not going to be able to meaningfully challenge the sentence. In other words, given what these women were saying, that even if she had been stone-faced, could have justified the finding that she made and the sentence that she imposed. So what are you going to say? The way that you did it was really troubling?
No, but why can't you say that the animus here is so, I'm not arguing it legally, but the animus is so out of control on the sentencing person that she wasn't objective enough to make that decision.
But the problem is that the sentence probably is independently justifiable.
Apart from this. Can I say one last thing?
Problem.
This gets back very quickly, if we can. This was under the radar to a great degree. You mentioned the right of victims to testify. The SJC, State's highest court, made a pretty important unanimous decision about a week or so ago. And here is from Justice Lowy, who wrote the unanimous opinion. A victim's recommendation, whether it be for a lenient sentence in the hope of redemption or for a maximum sentence commensurate with harm, is a relevant consideration in determining the appropriate sentence to impose. I don't mean this out of disrespect at all to the SJC. I have no idea what that means. I mean, is it revolutionary to say is a relevant? Well, of course it's a relevant consideration. It's not mandatory.
Well,
what is it? What does that mean?
It's the difference between when I was a judge, you'd have victim impact statements. The victim would get up and say, here's what he did to me and here's its impact on me. But you typically did not allow the victim to say, I think he should get 10 years.
Oh, so they should be allowed to comment on...
Right. This is basically allowing them to get involved in the what should we do with the person part of it.
But the only thing that the court is saying is you have to consider it, not that you have to do anything. Is that your interpretation?
It's not revolutionary, though. I mean, that's really been the practice in the Massachusetts state courts probably for a couple of decades. I think
for victims to recommend sentences?
Well, judges have been very receptive for a long period of time in terms of listening to the victims beyond the harm it's been causing, but in terms of what the victim's expectations are in the area of sentencing. The federal system, I think, is...
There's a clear line. It's talking about simply the impact,
exactly,
but not a recommendation with respect to sentence.
Yeah.
And that makes perfect sense. The sentencing is arguably a matter of expertise for others than the victim. It's not... this isn't a civil case. What the victim wants shouldn't determine the outcome.
Judge, nice to see you.
Nice to see you.
Thanks, Jim.
Vote for Bush, correct?
I did.
I want to be clear.